Hi, welcome to RodneyABrooks.com. I have a special guest today. We're talking with Ethel, prominent attorney Ethel Mitchell, who specializes in estates and trusts. She is based in Silver Spring, Maryland, but she practices also in Washington D.C. And Virginia. Now, Ethel Mitchell also has a radio show called Law Talk with Ethel Mitchell on WOL FM 1450 AM and 95.9 FM on the radio dial. Welcome.
Thank you.
Okay.
Thank you so much for having me.
So let's start off. With questions. So, a lot of people put off doing wills and any kind of estate planning. And so let's talk about, why is that a mistake?
Oh, it's a huge mistake. Number one, a lot of it is just from lack of information. A lot of us had parents who didn't have wills. And so you feel like, well, my mama didn't have a will, or my daddy didn't have a will. Why should I have a will? Well, number one, you probably got a lot more money and a lot more assets than your mother and your daddy. Number two, people are very litigious. In other words, they're quick to argue and fight with the family over your property. If at least you have a will or a trust, you have directed, number one, who's in charge and how it's supposed to be distributed, whether they like it or not. Okay, so as long as you have a proper will and a proper trust or a proper trust, it can be controlled. And unfortunately, death is the only certain thing that we have, even more so than taxes, okay? But we're leaving this earth at some point, and we're going to leave all our stuff here. So it's important to control it. You have the right under our law to control it, to say who gets your stuff, because somebody going to get it. So you might as well take care of it yourself, yes.
Okay, well, that actually leads me into another question, which is always directed at me. So explain the difference between a will and a trust.
Ah, yes, big one. A trust, for example, does not die when you die. Think about it that way. A trust is a legal instrument that lawyers create on your behalf, and it will continue after you die. A trust properly done and funded also doesn't have to go to court. It doesn't have to be litigated in court. You don't have to go to court to get permission to do the things that your trust, directs. It's got to be done right, and it's got to be properly funded. But a will does. A will has to be submitted to court. The person you name as the executor has to be appointed by a court. Usually the court has some kind of control over what happens. You have to file accounts, you have to file notices in the paper, you have to ask permission in many courts to do what the will says to do. And the will is going to distribute everything outright, one way or the other. A trust can last for generations. And those are like sort of the basic differences between a trust and a will. And there are a lot of different kinds of trusts, but those are basic differences. Yeah, a trust is private, for example. A will is public. When you die, your will is going to be admitted to court, and anybody can go look at it. There's going to be a report to the court that says how much money you had, what property you had, and who gets it. A trust is not admitted to court. It's a private document. It distributes your property. It names somebody to be in charge. And if you want it to last for time, you can make it last for your grandparents, your grandchildren, and so on. Or you can also still distribute it outright. It's up to you completely, yes.
Okay, so walk me through this, okay? What happens when you die without a will?
When you die without a will, there is, basically the law writes a will for you. If you remember, a will is called a last will and testament, okay? When you die without a will, every state has a law called intestate succession. And that means that the court says who gets what. And those rules are ironclad. It doesn't matter if you told somebody you were supposed to get this baby, or if one child did more for you than another, or you haven't even seen a child for years, or one child has a drug addiction or alcohol addiction and you really don't want him or her to get whatever you have, if you didn't write it down in a legally enforceable way, the court doesn't care. They're going to say, this is how the law says it goes, and this is how we're going to distribute it. And a lot of times it's not what you think. A lot of times it's not what you think. I'll just give you one simple example. When people are married and they don't have any children, for example, they assume, even though they didn't put it in writing, that their spouse gets everything when they die. Well, there have been some changes since October of last year in some of the states around here, but most states say, no. The surviving spouse gets usually like 2/3 or 3/4, but the parents of the deceased spouse get the other fourth. So a lot of times I have people come in and they're shocked to find out that they own the house with their mother-in-law or their father-in-law, because they just didn't, they just never took care of it. Or, for example, maybe a child was raised by one parent and not by the other. Maybe the other parent never contributed to that child. But when she dies or when he dies, if he didn't have a will, both of those, and he doesn't have children or a spouse, that parent who didn't do anything for them can step in, and I've seen them do it, and take half of whatever it is that they left. So if you die without a will, you're leaving it up to the courts and to a large extent to chance to determine how your assets are distributed, who's going to be in charge, for example. There are a lot of fights about who's in charge when somebody dies, and it's a real mess, an unnecessary mess, too.
Okay, now, it sort of, again, leads us into another question, which many people are surprised, and that's when it comes to beneficiaries and why it's important to keep those updated.
Oh, yeah.
They don't realize that beneficiary basically aces a will.
It does.
Yes.
Your beneficiaries, for example, if you have a checking account and you say, I want, and you name your beneficiaries, that overrides what's in your will, okay? Retirement account, any kind of an account. If you put down beneficiaries on it, that overrides what your will does, or even your trust for that matter. Okay, so it's important, like insurance. We have a lot of insurance policies where they never change the beneficiary after a divorce, for example. And then the divorced spouse ends up getting the money from the insurance. There are few states that will stop that, but if you don't update it, yep, they're going to get it, because that's who you told the company to give it to.
And I know in a lot of cases, people basically forget to change when they get married, and their parents, especially their mother and father, is still the beneficiary.
That's one of the reasons why in our firm we really try to work with people with their beneficiary designations as well as do their documents. Like, we ask our clients to bring in all of their beneficiary designations. We get one statement from every account and put it in the estate document book that we have. And if they need help making the changes, we'll write it out for them, but then they have to actually follow up and send it in. But those are really important. They really are. Yeah, that's all part of estate planning. We also look at the deeds, for example, because a lot of people think they own something, and you get the deed and you find out, no, it's actually still in my mother's name or my father's name or my grandparents' name sometimes. And so then we have to go through the process of trying to get it to the person it's supposed to go to, and that can be a hassle.
Okay.
Yeah.
Okay. Now let's talk about the process for a minute. Okay. So somebody shows up or makes an appointment in your office. How long does it take, and what is involved in basically putting together a will or a trust? Okay.
In our office, Wills and Trust LLC, we have 3 lawyers. First of all, myself, my son, who's attorney Ronald Scott Mitchell, and attorney Brenda Morton. We all work together. The first step is to make we offer free consultations, okay, a free 15-minute consultation, just to find out what you're interested in, what your issues are, and just briefly give you some advice on what we would recommend. and we'll say, okay, you need a will. Sometimes we can do a will and a deed and beneficiary designations, and that'll work, you know. So we might recommend that. Sometimes we might want to do a trust. If you have children or grandchildren or minors or disabled beneficiaries or someone that you want to take care of if, God forbid, you got sick, okay, and died, and then we're talking about a trust in that instance. Sometimes you want to be private. You don't want to go through probate. But whatever it is, once we know that, then we tell you this is what we recommend. If you say okay, then we'll give you a price, you know, what it's going to cost, how we're going to bill you. And if you say yes, then we'll do an engagement letter, a retainer that you can pay online, okay, and you sign the engagement letter by DocuSign. And then we send you also a longer client information form. And because we also do wills, trusts, power of attorneys, medical directives, the whole 9 yards. So you have to tell us who's going to be your medical agent, you know, and we'd like at least 2, sometimes more. Who's going to be your power of attorney? Who's going to be your executor of your will? Who's going to be the successor trustees for your trust? So we send you a form for you to fill out and give us that. We also send you what's called a chart, list of assets, where you list what your assets are, you know, bank accounts. We don't want numbers, you know, we don't want account numbers, I'll put it like that. But if you have an account at PNC, you know, is it an investment account? Is somebody else's name on it? You know, all those, you know, what properties you own and so forth. And that way, when we have our next meeting, which is going to be a much longer meeting, we can really ask you specific questions about how do you want this to go? Who do you want to get this property? Are you concerned about someone in particular? Maybe they don't manage money well, you know. Maybe you want to make sure your grandchildren get something. Who's going to be in charge of your grandchildren's share, you know? Maybe you say, I love my daughter's husband, but I don't want him to have his hands on my grandchildren's money, you know. Whatever it is, tell your lawyer, because then we can draft around it. You see what I mean? We can draft around it. And then, after that meeting, we do the initial drafts, okay? We have another meeting where we put that on the screen, and we go over them with you in detail. And we answer your questions. Sometimes people want to see it themselves. If so, we'll email it to you and give you like maybe 2 weeks and have another meeting and say, okay, are you comfortable with this? Are you not comfortable with that? You know, maybe you want to change somebody's name or the order in which they are. And then after that, we do that. We have one more meeting, and then you come in to sign.